Hi, everybody, and welcome. I'm Laurel Sauer.
And I'm Alan Gerstel. Thanks for joining us for Heritage, a series of unique, award-winning local programs originally produced by WXEL's partners at the Education Network.
Now, tonight, we get a first-hand look at our legal system. Many of us think we understand how it works, but thankfully, most of us have never had a run-in with police that would actually lead to our arrest.
So we're going to show you one young lady's DUI arrest as captured by a deputy's dash cam. And we're going to follow her into the Palm Beach County Jail and into the legal system to learn what the defense does, what the prosecution does, and what the judge does and doesn't do.
And then we'll hear from Palm Beach County's Chief Judge, Peter Blanc, as he answers questions posed to him by students. And you may be surprised by his answers to some very pointed questions. So here now is the legal system.
Okay, let's give you registration and insurance. How long you lived in Florida?
I'm actually from North Carolina. I'm just visiting right now.
Oh, you're visiting?
Yeah.
Okay. Is there a reason that you just drove like extremely fast and ran 2 stop signs in that parking lot in that street back there? How much you had to drink tonight?
Just 2 beers.
2 beers?
Yeah.
What time?
I think I got there at like 11 o'clock or so.
Do you have a Florida license?
No, it says it's an ID card.
Have you ever had a Florida license?
In the past, yeah.
Where is it?
I don't have one anymore.
Oh, it's no good?
No.
What are you looking for right now?
I'm from North Carolina.
You're looking for your North Carolina license?
Yeah, and it should be totally in here, and it's not.
Do you not recall handing it to me?
Are they able to understand instructions? Are they able to have a conversation with the officer? If the officer asks for their driver's license, do they respond appropriately?
How much did you have to drink tonight?
2 beers.
2?
Yeah.
So after 2 beers, you can't remember 3 times that you already handed me your license? All right, what I'd like you to do is stand on the light and face me, please. Put your feet together, your hands here. I want you to remain like that. Don't start until I ask you. Do you understand? When I ask you to begin, whatever leg you choose, and I don't care which one, you're going to hold one of them 6 inches off the ground, like so, with your foot straight. I want you to look at your foot and count. 1001, 1002, 1003, and keep counting like that until I ask you to stop. Do you understand those instructions?
Yeah.
Go ahead and begin, please.
1001, 1002, 1003, 1004.
Are they having a problem with walking, with talking? Do they have slurred speech? Do they have a flushed face? Do they have bloodshot glassy eyes?
I'm honestly not a big drinker. I don't know if 2 beers did it for me or not.
Well, I think it did because I didn't ask you to move your foot whatsoever on this. Turn around, please. Place both hands behind your back. I am placing you under arrest for DUI. Do you understand that?
Oh my God. Oh my God. I'm getting arrested. Oh my God.
Information that comes out when you're sitting in the back of a police car that's not in response to questioning, meaning it's spontaneous statements that you're making, can be used against you. Because in the back of a police car, you don't have a reasonable expectation of privacy.
You really need to do this to me? I'm not a drinker. I got cheated on. I had 2 beers. I'm not a drinker at all. You have to do this, don't you?
I am arresting you, yes.
I've never been arrested in my life. I can't believe it.
The duty and obligation of a prosecutor is different than that of a police officer. A police officer arrests with what is called probable cause. But the burden that the prosecutor have is they have to take all of the evidence in the case and they have to present it to the jury or the fact finder, the judge in some cases, and they would have to prove that the crime charged is in fact what happened, and they would have to prove that with a burden of beyond a reasonable doubt.
Prosecutors can use police reports and police testimony. They can utilize photos and dash cam video. And they can also call witnesses and present additional evidence to help convict an offender. A DUI conviction for a first offender carries a 1-year probation, even if the offender is as young as 13. A driver license suspension for a minimum of 6 months. A minimum of 50 hours of community service. And a minimum $500 fine and court costs. And there's more. A DUI conviction results in a permanent criminal record that follows an offender for the rest of their lives, making it very costly to get car insurance. That permanent criminal record is also very difficult to hide from future employers.
It's important to understand that the duty of a prosecutor is to seek justice. It's not just to get convictions. When a prosecutor has a case, they need to understand that the obligation is to the victim. They need to protect the innocent victim as well as convict the guilty. But in obtaining that conviction, they actually have to safeguard the rights of the accused as well as enforce the rights of the public at large.
Prosecutors have an ethical duty to take cases to trial only when there's a reasonable likelihood of a successful prosecution. If they don't have the evidence to get a conviction, they must drop the case.
Oftentimes, the charges that the person is arrested on may not be the charges that actually are what is filed. You can look at a person's prior record and maybe file something as a felony because of prior convictions. Certainly in a DUI case, if a person had several prior DUIs, it could be filed as a felony, 3 or more.
Miss, we're going to place you in the breathalyzer area for 20-minute observation, and then we'll take you over to the jail. And we're going right through here.
There's one next in with some paper.
I need you to have a seat right there on the bench. Have a seat. And I'll be right with you.
Hey, ma'am, come in here. I need you to place your back and face the camera. Keep your head straight.
When your photograph is taken now and you're arrested, you need to assume that it will be everywhere.
Your mugshot becomes public record and will likely appear in your local newspaper. It may even show up on internet sites like Twitter and Facebook.
And to your right. You're going all the way down to the gray chairs down here.
Most people have very little contact with the legal system other than a simple traffic ticket. Others, like this young lady who's been arrested for drunk driving, will become immersed in it, from their arrest to their booking in the county jail to their day in court.
You're going to have a seat right here in the gray chair. Ma'am, come here, please. I see your right arm. Thank you. You're gonna have a seat right back here, ma'am.
DUI suspects spend 8 hours in a holding cell and given a second breathalyzer test before they're released. During that time, many will consider the need for a defense attorney. So, when should someone call a defense attorney?
When someone has been arrested, when someone may be under suspicion for being involved in criminal activity, when someone's a victim of a crime and wants a personal representative to help them through the criminal justice system.
In fact, anytime they need someone who will defend them and have their best interests at heart.
When you go to court for the first time for your arraignment, when you're entering a plea of guilty or not guilty, your lawyer or yourself will get what's called the discovery packet from the prosecutor. What that is all of the police reports, a listing of all of the evidence against you.
In DUI cases, that would include dash cam video, breath testing, audio tapes, photographs, witness statements, and a list of all the witnesses they plan on using against you.
Before you make any statements, your Miranda rights need to be read to you if they're going to be used against you with law enforcement or in a court of law. But most people are under the misconception that immediately upon arrest, your Miranda rights need to be read to you. And that's not necessarily the case.
As in this case, where this dashcam video may be strong enough evidence to gain a conviction even without any statements from the defendant that she only drank 2 beers. The ultimate decision on this case and others like it will play out in a courtroom like this one. The prosecutor is on one side and will present the case to the court. The defense attorney is on the other side, ready to defend his or her client. The case may be heard by a jury or by the judge him or herself.
Ordinarily, any case involving due process issues or liberty issues, in other words, criminal cases where someone could go off to jail or prison, that person is entitled to a trial by a jury of their peers.
However, cases heard in juvenile court, family court, and probate court are the exceptions to that rule. In cases where a jury is impaneled, the judge sets the ground rules.
Now, the judge, in applying the law, will determine what testimony and evidence the jury will see and hear. Some of it may be admissible, some of it may not. So the judge in that case rules on issues related to the law, which determines what the jury sees and hears. The jury then determines the outcome, guilty or not guilty, based upon the facts as they find them.
In capital cases where someone could be subjected to the death penalty, juries consist of 12 members. But most cases would be tried before a 6-member jury.
And the 6-person jury is picked randomly. Ordinarily, a judge will ask for at least one alternate juror. An alternate juror is someone who sits with the jurors as if he or she was a regular juror. Ordinarily, the alternate doesn't know that he or she is the alternate. If the case reaches a conclusion and the jury begins to deliberate and we still have all 6 of the original jurors, the alternate is excused at that time.
If one juror becomes ill during trial, the alternate can fill in because they've all listened to all the testimony. But no matter the size of the jury, the judge presides over the case, makes decisions regarding the law, must be fair and impartial, and must be a good listener and good communicator in considering everyone's position.
Because usually, in most cases, people disagree on what the facts are. People disagree on what the outcome should be. And when a judge is asked to decide what that outcome should be, it's easy for the side that feels that they have lost to think, well, that judge had his mind made up or her mind made up, or the system's not fair because I didn't get to present all of my testimony or evidence.
The prosecutor presents testimony or evidence on behalf of the state. It is the prosecutor's responsibility to seek justice, not just get a conviction. The prosecutor decides what charges to file, if any. The prosecutor may offer a plea bargain before going to trial. And once at trial, the prosecutor needs to prove the charges beyond a reasonable doubt.
We have an ethical duty to only take cases to trial and to only proceed on cases where there's a reasonable likelihood of a successful prosecution. If the facts and circumstances do not meet that level, and when the state can't prove the charges beyond a reasonable doubt, justice in that particular instance would then be to drop the charges.
Under our system of law, the defendant, in this case the young woman accused of drunk driving, always has the opportunity to defend themselves, usually with the assistance of a defense attorney.
And really what we do is we help negotiate, we help guide people through the criminal justice system. A lot of people have never been involved with it before, and it's very confusing, it's very scary. You're dealing with law enforcement, you're dealing with a prosecutor, you're dealing with a judge, perhaps a jury of your peers, and it's a very scary situation. Most times, it's the absolute worst thing that's ever happened to someone.
The defense attorney guides defendants through the legal system, has an open mind and must be objective, helps negotiate plea bargains before going to trial, challenges evidence and/or testimony at trial, and has their client's best interests at heart.
Because the criminal justice system does not work without defense lawyers like me. Nobody wants a guilty person to go free. And I'll tell you, it doesn't really happen that often. But no one wants an innocent person to go to jail. And so what I do is I make sure that everything was done right, that I review the facts with my client. I make sure that the police did not violate my client's constitutional rights.
That means police did not take the statement illegally. They didn't obtain evidence improperly. They didn't plant any evidence. In fact, they did everything appropriately. But surprisingly, very few cases actually go to trial. The majority of cases are resolved by a plea or some sort of negotiation.
It's very easy to point the finger and be a prosecutor, and it's very challenging to defend. And a lot of people look at the defense attorney as wearing the black hat, but that's not my opinion. I feel that I really am the last defense of the Constitution to make sure that everything was done right.
There is a certainty in our judicial system that everyone makes mistakes despite their best intentions. And that's why our legal system has an appeals process.
Appellate judges don't try cases. They don't take testimony or evidence. What they do is they will review the record from a lower court or a trial court, and they'll hear arguments of the attorneys on both sides who will brief the courts, and that's where the term brief comes from, to tell them, yes, they think the court below committed a legal error that should result in a different outcome, or, of course, if you prevailed in the lower court, you'll say, no, everything was fine.
If the appellate court finds an error in the trial, it can send the case back to the trial court or reverse the decision of the trial court. But the legal system is not limited to criminal courts. It also encompasses civil courts, where anyone can sue for damage or negligence. Family courts that determine custody, visitation, support, and paternity decisions. Probate courts that deal with claims on estates. And juvenile courts that deal with dependency and delinquency. The legal system is part of our judiciary system, which is one of the three branches of our government. The other two are the legislative branch, which consists of the House of Representatives and the Senate, and the executive branch, which consists of the President, Vice President, and members of the Cabinet.
If we didn't have the legal system, we wouldn't have a way to resolve our disputes peacefully. And you've seen in other countries, when disputes cannot be resolved peacefully, what happens. You've seen what happens to governments when elections are challenged and people can't find a legal way to resolve disputes. If we didn't have a legal system that did that on the big issues and all the way down to the small issues, people would have no recourse other than to take the law into their own hands. And we know how well that works or doesn't work.
Do you not recall handing it to me?
Are they able to understand instructions? Are they able to have a conversation with the officer? If the officer asks for their driver's license, do they respond appropriately?
How much did you have to drink tonight?
Oh my God. Oh my God. I'm being arrested. Oh my God.
All right, good afternoon. It's nice to be with you live. You had a chance to see me on video. My name's Peter Block. I'm the Chief Judge here in the 15th Circuit, which is Palm Beach County. And I'm here to answer any questions you have after having the opportunity to see that video and the information it provided. So let's get right to it. Who has a question? Yes, ma'am.
Your Honor, why is it that in some cases in the arrest, Miranda rights aren't immediately read upon the arrest?
As opposed to other times when they are not? If an officer believes, or a detective, whoever is the arresting agent, believes that they're immediately going to make inquiry of a suspect upon arrest, then it's important that they read the Miranda rights at that time, because they want to make sure that if any incriminating statements are made, they'll be able to use it later on. If there's not an intention to inquire or question a suspect, then it's not critical at that point in time. And if they decide later on to interrogate a suspect or ask questions, then they'll read the Miranda rights at that time. Yes?
Let's say if in a case that you were presiding over, the person had failed the field sobriety test. Those exams, like the balance, like walking in a straight line or holding your foot up. Personally, I have horrible balance. So if, let's say, I was pulled over and I failed that, and let's say I was taken to court, what would be your reasoning? Would that be more likely to say that yes, I was impaired, or what?
You mean, would I find you guilty just because you have bad balance? Well, if you look at it, they do a number of different tests. They'll do this. They'll do finger to nose. They'll do walking a straight line, heel to toe. But they give you a variety of tests so that if you say, I just have terrible balance, then you can rely on the other tests that were given. And you can rely on the totality of the circumstances, all the information. How were you driving? How did you speak? Were your words slurred when you were talking to the officer? Did the other things you do make sense? Were they logical or coherent? And if they're arresting you, they'll give you a chance to take a breathalyzer. And if you hadn't been drinking and you have bad balance, take the breath test. So there's a lot of circumstances. It's not just any one test. Yes?
As a judge, do you think it would be better to be a prosecution attorney or a defense attorney?
Well, I have a bias because I started out in the public defender's office. And so from my perspective, I agreed with what Michelle Suskauer said. They're both very important and very critical jobs, and both of them need to think independently and critically. One of the reasons that I went to law school, even though I didn't know at the time that I wanted to be an attorney, was I thought it was a great education because it taught you how to think and analyze critically. And that it does. And whether you're a prosecutor or a defense attorney, you have to do those things. Now, as a prosecutor, when you're trying to prove a case, you look at the statutes, and any crime has specific elements. DUI, they were drinking, they were impaired, they're impaired to the extent that their actual physical control was negatively affected. So you go through your case and you go through your facts and you say, okay, I have to prove A, B, C to make my case. And that's fine. For the defense, there are as many different defenses to a crime as there are theories about how the crime was committed. So when you are a defense attorney, you're not just proving elements of a crime, you're trying to prove that the crime wasn't committed. And it may not just be putting on evidence of A, B, C. You have to be persuasive to a jury that your theory of defense is important and it makes sense and it applies to the facts of the case. You have to convince a jury who's looking at the facts that this is the way you should find the facts. Because the jury decides the questions of fact, the judge decides the questions of law. So you want to be able to convince that jury that your theory of how this all happened is what they should agree with, and not whatever the theory of the prosecution is. So from my perspective, defense needs to be a bit more creative, but I don't say that to take anything away from the prosecution because they have a very tough job as well. Yes, ma'am.
What do you like most about your job?
What do I like most about my job? I feel like I get to make a positive difference in people's lives. I feel like I get to resolve disputes peacefully in a way that a lot of countries can't do. I feel like I get to listen to beautiful, intelligent arguments from both sides of a case, civil or criminal. And I feel like I get challenged every day. I feel like I learn something every day because as much as we do this, you know, there's a tendency to think, well, I've heard this before, like the two-beer thing that you saw in the video. When I was a county court judge in the criminal division, I can't tell you how many times I heard what they would call the two-beer defense. Oh, I only had 2 beers, because it's the easiest thing for people to say, and they think, well, that doesn't sound too bad. But you have to remember that there are people that really only had 2 beers, and maybe their balance is bad, and maybe they're having a bad night, and maybe they're emotional because they had a fight with their boyfriend or their girlfriend, and that's affecting their behavior. So you learn something new every day, and it keeps you honest and it keeps you humble, because as much as you want to think, well, I've heard this before, you know, every day Life is full of surprises, and you hear something new. I could think, when hearing one side of a case, well, I know how this is going to go. And then you hear the other side, and you think, well, I never thought of that. You know, that makes sense. And so it really keeps you balanced, and it keeps you learning, which is a good thing. We're out of time, but I want you to do one thing before we leave. Everybody stand up. Put your hands at your sides. Look straight ahead. Lift one foot, I don't care which one, 6 feet out, and count to 10.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Okay, who are we going to arrest in this group? Right here. Okay. All right, thank you very much for letting me come do this. I really enjoyed it. Thanks a lot.
We'd like to thank Judge Peter Blanc, the Prosecutor's Office, and the Palm Beach County Bar Association for their participation in this program. And we'd like to thank the Palm Beach County Sheriff's Office for that dash cam video.
That video certainly made the experience all too real for everyone watching, Alan. I know it did for me. In addition to educating our viewers, we hope that it will also make you think twice before drinking and driving. For WXCL, I'm Laurel Sauer.
And I'm Alan Gerstel. We'll see you next time on Heritage.
And if you have any questions, comments, or suggestions, feel free to email us at heritage@wxcl.org.